case briefs, and so much more. LSData's got what you're looking for.
Burlingame Capital Partners 2, LP, navigated troubled waters when it landed in a high-stakes lawsuit. The venture capital firm was being sued by a trustee, John Kendall, on behalf of an electroplating business that had filed for Chapter 11 bankruptcy. The lawsuit revolved around issues of security interest, specifically the transfer of this interest, all within 90 days preceding the firm's bankruptcy filing. As the trustee attempted to recover these transfers, Burlingame fought back, asserting that the transactions in question did not adversely impact unsecured creditors. The firm claimed protection under Section 11 U.S.C. Section 547 C.5 of the United States Bankruptcy Code. The crux of Burlingame's argument was centered on this code section, which allows a trustee to avoid a transfer if it reduces the overall secured debt in prejudice of other creditors with unsecured claims. Burlingame maintained that this exception applied to their actions. In their context, they argued, secured debt referred to no other than their securities, the debtor's accounts receivable and inventory, which produced cash proceeds that were then used to carry on business operations. Yet the court wasn't convinced. It brushed off Burlingame's motion for summary judgment, citing lack of evidence. Throughout the 90-day preference period, Burlingame was an undersecured creditor, meaning its collateral was valued at less than its debt. Burlingame, the court maintained, failed to provide evidence that its financing of labor costs led to the creation of new security interests during the contentious period. Moreover, the court dismissed Burlingame's claim to an automatic blanket lien. Such an argument, it suggested, was inconsistent with the principles of the Bankruptcy Code, deeming it insufficient to shield them from the trustee's claim. The outcome was clear. The plaintiff had to bear the burden of proof for the elements of a preference claim, while the defendant was left to grapple with their defense. Burlingame's reliance on 11 U.S.C. Section 547 C.5 and its argument around avoiding transfers ultimately fell flat due to lack of compelling evidence. In the end, the court's decision posed a stark refutation to Burlingame's claims, marking yet another chapter in the delicate dance between bankruptcy law and venture capital.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.